Hello, welcome all. Myself Kiran. Today we learn about case study of neem patent. First, let us see the outline. What is patent? Introduction, patent system and its purpose, legal challenges, global response, and last part is how the case was resolved. First, let us see what is meant by patent. Patent is a legal document granted by the government that gives the inventor exclusive rights to their inventions. Okay, I will tell it in simple words. Patent is nothing but a right that is given to the inventor by the government over their invention so that other people can't use them without their permission, and the duration of this patent is over 20 years. Okay, let us see the introduction. A tree, neem, a tree native to India, holds cultural, medical and agricultural significance for centuries. Neem has lot of usages in various fields, and among them the two fields are medical and agriculture. Okay, traditional medicine. Neem leaves and oil are used in traditional medicine for healing skin, digestive issues, and more. That is, if you consider the medical field, neem is used for healing the skin. Okay, and agricultural benefits. Neem is a natural pesticide fertilizer and contribute to soil health in sustainable agricultural practices. That is, if we consider the agricultural field, neem is used as pesticide and fertilizer. Okay, and cultural significance. Embedded in Indian traditions, neem symbolizes the purity and is often associated with festivals and rituals. Recently, we celebrated Makara Sankranti, right? In the Makara Sankranti festival, we used neem leaves, and it symbolizes the purity. Okay, and versatile uses. Neem's diverse applications include cosmetic, soap, toothpaste, and even the pet care products. Okay, and as neem is used for making soaps, cosmetics, toothpaste, etc. That's the meaning of this statement. And environmental friendliness. Neem's eco-friendly properties contribute to pest control without harming beneficial insects or the environment. That is, neem is so specific that it only targets the target insects. Okay, it will not affect the non-target insects. That's what the meaning of this statement. Okay, and the global recognitions. Neem popularity extends globally for its natural properties, attracting attention in various industries worldwide. It is the neem plant as a global recognition because it has lot of usages in different fields. Okay, and balancing tradition and innovation. Recognizing neem's tradition importance while exploring the modern applications fosters the harmonious blend. And the overview of the patent system and its purpose. Patent system overview. Patent is a legal rights granting inventors exclusive control over their inventions for their specific period. As I told, patent is nothing but a right that is given to the inventor by the government. Okay, and that's the meaning of this first statement. Purpose of the patents: encourage innovation by offering inventors protection, promoting research and sharing knowledge. Okay, purpose of the patent is nothing but making sure that other person don't use their inventions for the wrong purpose. Okay, that's the main purpose of the patents. And neem patent introduction. Neem patent refers to specific legal protection granted for innovations related to neem. That is, if a person does the invention with respect to neem, he will be having the patent. That's the meaning of the neem patent. Okay, and date of the neem patent. United States Patent and Trademark Office, that is USPTO, granted a patent for neem in 1995. However, the European Patent Office EPO revoked the patent in 2002, upholding the India's claim that neem tree is a part of traditional Indian knowledge. Okay, the neem patent was earlier, it was existing in 1995, but it was uh, revoked in 2002 by EPO, that is European Patent Office. That's what the meaning of the statement. Okay. Now this is the legal challenges. Public outcry. Widespread public disagreement and concerns expressed regarding the neem patent's implications on traditional practices. Okay, I will tell you by giving one example. If we consider one group of people, that is, let us say the research people, they want to get it patented. Okay, and if we consider other group of people who does not do the research, but according to them the neem is a traditional thing, right? But if once they do the patent of the neem, that other people like traditional people can't use it for their use, right? So there was a public outcry. Okay, opposition from the communities, indigenous communities and organization opposed the patent, asserting it violated the traditional knowledge and practices. Once it is patented, right? If the name is patented, other people can't utilize it, right? Because once it is patented, the rule itself says the people who use the name has to take the permission from the inventor. Okay, so there was an opposition from a lot of committees and impact on traditional use. Lawsuits argued that neem patent could have negative effect on traditional use of neem such as medicine or agriculture. They were concerned that the patent might restrict or hinder these from traditional practices. Okay, and let us see the impact on indigenous knowledge. Biopiracy concerns. People worried about biopiracy where commercial interest exploit biological resources without fair com- compassion or recognition. That is, in the name of research, people can over-exploit the name, right? So it can lead to biopiracy. That's what the meaning of the statement. Traditional knowledge threatened. The name patent raised the concerns about the patent threat to indigenous communities' traditional knowledge. Once it is patented, they can't use their knowledge, right, regarding the name, because the rule itself says they can't use the they can't use the name without the permission of the inventor. So it threatened their knowledge. Okay, and cultural appropriation worries. A patent sparked fears of cultural appropriation as it invoked claiming ownership over knowledge deeply rooted in cultural practices. Limiting access to resources. Concerns were raised that patenting could restrict access to neem related resources for communities relying on them for their livelihood. Okay, the meaning of this statement is there are many communities that rely on the neem plant for their livelihood. Once the neem plant and its invention is patented, the people who rely on them, who rely on the neem, cannot use it, right? And the communities will lose their lives, etc., because they will not be having the access to neem, right? And the global response, international outcry. The neem patent controversy triggered strong reactions globally, drawing attentions from various countries and organizations. That is, there is one set of people who want to get the neem patent, but other set of people who don't want to get the neem patented. Among these two groups, there was a clash, and it created a global controversy. And public awareness campaigns. Awareness campaigns were launched worldwide, informing the public about the name patent and its potential implications. That is, there was lot of campaign educating the people what are the drawbacks if they do the name patent. Okay, and reevaluating international agreements. Some international agreements related to intellectual property rights were reevaluated in the light of NIM patent case. That is, there are some few countries where NIM patent was revoked. So, in so it was revoked because of the cultural implications. Okay, and how the case was resolved. Okay, but before going to this topic, I would like to say a few words. In India, there are about 14 to 13 patents still existing now, but what I am taking here is, if we consider the neem as its usage in agriculture, it is used as pesticide, right? It was patented earlier and it was removed. Okay, how it was removed, all those things I will be mentioning here. Okay, and in 1994, European Patent Office, that is EPO, granted a patent in USDA and WR grace for neem-based biopesticide. Okay, that is, this EPO granted patent for biopesticide if you use the neem in them. Okay, and Indian government challenged the patent in EPO, arguing that fungicidal properties of the neem were already well known in India, and that the patent was granted in violation of the Indian traditional knowledge. That is, there was one group of people who told that neem in the neem we have found out the pesticidal property and we will be patenting that. But India challenged that we already know that we are practicing it as a traditional. It is a tradition for us, so it can't be patented. And in 2002, EPO rejected the WR Grace appeal against its against its order upholding the India's plea. That is, in 2000, the patent was cancelled. Okay, and this is how the case was resolved. Thank you. Have a nice day. If you have any doubts, feel free to write the comments in the comment box.